the Helena Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and shall be heard.
Thank you. Please be seated. Good afternoon. First cases for argument are number 527 through 530. Mr. Malash? Walsh, I apologize. You may proceed.
Please the court, Your Honor, Judge Walsh, on behalf of defendant Helen's Community LLC. Cases you are going to hear this afternoon all arise out of a horrific event that no city community person should ever have to endure. On May 14, 2022, a person murdered, assaulted, and battered numerous innocent persons in or around the top spreading market in Buffalo. The shooter scouted out this location for months and targeted this particular location based on its racial profile. In fact, the shooter drove 200 miles from his home to Buffalo on several occasions just to scout out this location as a potential target. This was not an act driven by impulse or instinctive rage. It was a meticulously planned attack. The plaintiffs are the victims of the shooter's crimes. They bring these lawsuits seeking financial recoveries, at least in part, from a Georgia business called Lean LLC. That's our client. Lean LLC never had any communications with the shooter before this incident. Not in any way participating in the planning, they had no knowledge of the shooter's plans or intentions. Despite this lack of relationship to the criminal wrongdoer, potential tortfeasor, the trial court incorrectly held that plaintiffs had adequately pled violated legal claims against Lean.
Counsel, it appears that we understand the factual background. It appears that the primary issue here is whether your client's magazine lot is a qualified product of the statute.
Your Honor, I would agree that's an issue in this case. I would argue that the primary issue is proximate cause. I don't think the court even has to get to the TLCA to dismiss Lean in this case.
We, if it were a jury trial, we wouldn't get the proximate cause first. We would get to that only if there's a violation.
Correct, Your Honor, but proximate cause based on plaintiff's general tort theories, whether it's the TLCA or negligence, negligence per se, it's an essential element, and it's the easiest out.
Right, just your brief wasn't structured that way, but you're free to argue in whatever order the shoes you wish.
Thank you.
And Counsel, just to follow up with Justice Pizzani's question, from my perspective, in any event, this is one thing that will encounter with me, is if I'm going to address proximate cause, I'm going to want to address the first two questions on the verdict sheet first. That is, I'm going to want to have to assume that your client had a duty and that your client breached that duty. And then we'll analyze whether or not your client's conduct, breach of duty, was a proximate cause of the ultimate events. So I don't think that you could look personally in proximate cause in a vacuum. I think it has to be with the assumption, at least assuming arguendo, that there was a duty and your client breached. So when you're going to get to that point, at least for my purposes, please try to address it in that fashion.
Sure. Your Honor, the way that I was going to approach proximate cause was just that. Assuming for purposes of this early stage and this argument that Lean somehow had some sort of negligent conduct, whether it's through marketing, whether it's through sale, whether it's somehow it's an defective product, whatever that basis is, the duty and the breach, once you get past that, you still hit a roadblock at proximate cause. Proximate cause can be a basis for dismissal at the motion to dismiss stage. I agree that it's not often done. It's faced unusual circumstances, but this is that case that is so unusual, so exceptional, so on the edge, that this is the type of case where we shouldn't have to go through discovery, we shouldn't have to get through 3212, we shouldn't have to go to trial on proximate cause. When the shooter,
What's your working definition of proximate cause with respect to foreseeability? How would you frame the issue? What needs to be shown here to show proximate cause?
sure. I mean, I think if you look at the Scurry case, the Hain case, the Tennant case that Judge Smith is very familiar with, it should say it's well established that an intervening intentional criminal act will generally sever the liability of the original tortfeasor. The court, in Tennant, the court pointed to a lack of notice or red flags in that case to show that was after summary judgment. So to establish proximate cause, it must be a normal consequence of the negligent act that is reasonably foreseeable. There's nothing normal about what the shooter did in this case. There's nothing reasonably foreseeable about what the shooter did in this case After his all of this, remember, emanates from me, which sold those two pieces of red metal. It's a sleeve that goes into the rifle, and then you screw it in, and the end of the screw shears off. It's a pin.
Would you agree that it might be foreseeable that somebody would use the lock and then remove it in the fashion that the shooter did? That may be foreseeable, that much of it?
It's clearly foreseeable that someone would remove this lock, because we put instructions on our package on how to remove it. And the reason for that is in 40 out of 50 states in this country, they don't have laws like that.
But would you agree it's reasonably foreseeable that somebody in New York or California, where your magazine limit was 10, would have this means lock on a rifle to make it legal in the same pattern? And reasonably foreseeable that somebody would then take that off to use high-capacity magazines? You would agree with me that that's foreseeable? I'm not talking about what someone's gonna do with the high-capacity magazines later, but that step of it is
The problem with that analysis, Your Honor, is you can buy this rifle in New York today with detachable magazines. You can't just buy a rifle, a semi-automatic rifle in New York with a fixed magazine. If that was the case, Your Honor, I can see where you're going. But in New York, you have two options when you buy this rifle. You can buy one with an detachable magazine without certain features, or one with a fixed magazine with features.
both limited to $10.
Both limited to 10, and once you take either if you buy a rifle with the ability to take the detachable magazine, or you buy a rifle with a fixed magazine and alter it so that it can accept a detachable magazine, whether it's a 10 round, a 20 round, a 30 round, a 100 round magazine, nothing stops anyone from using any of those magazines other than the law itself. There's no mechanical function in any AR-15 rifle that prevents someone from using a 10, 20, 50, or 100 round magazine. So I don't think it is foreseeable that someone would take the mean lock out of the gun, which destroys the product in so doing. Then go to Pennsylvania to buy illegal magazines once it comes across the border. So we have committed another act. Now he has illegal features, he's got illegal magazines, he's got all kinds of ill intentions. I don't think any of that is a normal consequence of me selling this lock, or a reasonably foreseeable event.
Your friend sitting to the right would suggest that it was foreseeable, and that the YouTube videos that he's put out kind of anticipated and encouraged, suggested this as a possibility to get around these unfair and onerous laws in New York.
Sure, and that's their spin, but if the New York resident wants to retire and move to South Carolina, Georgia, Florida, Alabama, South Arizona, New Mexico, Texas, they should have the option to remove the whatever's fixing their magazine so they can get it back to its original design, its original intended function. That's the reason why it's removable. The reason why it's removable is if someone moves to one of the other 40 states where this is completely legal to have a fixed or detachable magazine without any limit, they can do that. They can get it back to its original design. So
I have to tell you, Counselor, I'm surprised that you started with your proximate cause argument first, because that is a typically, especially in New York laws, I understand, very fact-intensive inquiry. And now you have conceded, as I understand it, that it was reasonably foreseeable that someone would remove the lock, that is, remove the lock in New York. Wouldn't it then be reasonably foreseeable that somebody in New York would remove it for criminal purposes?
I don't think you could ever reasonably foresee someone who's going to use a legal product for illegal purposes, and certainly not this person. In this case, which is, the facts are well, and I don't ever dispute whether we get past this motion to dismiss or we get to discovery, get to trial. The facts are going to be the facts. He bought this rifle 5 months before the incident. He's wrote a 180-page manifesto on how he was going to do this. He talked about what socks to wear, what underwear to wear, what type of ammo you use, what type of rifles you use, which are the benefits, which are the positives. He was so intent on committing this crime somewhere that nothing was going to stop. If the mean lock never was invented, this crime happens. There's no way someone could reasonably say without pure speculation that the shooter was going to, he couldn't have committed this crime or wouldn't have committed this crime if the mean lock didn't exist. He was searching out store after store after store looking for the right rifle. He selected this one for whatever reason and knew when he bought it, he was going to take out the mean lock. I don't know how we can argue that it's not reasonably foreseeable that someone can take out the lot when we have instructions on the back of our packaging instructing people how to do it. That doesn't just make sense. But the next step, when someone, is it normal, is it a normal consequence that someone would remove the lock and then, which is already breaking law in New York, and then no one would go to Pennsylvania or whatever state you want to go to buy a 30-round magazine, and then come across New York and break the law again, and then do all this planning and all this reconnaissance. It just doesn't make sense, common sense or legal sense, that whether this mean lock exists or it didn't exist, whether it was in the rifle or not in the rifle, whether it was ever invented, whether it was ever sold, that was not going to be a substantial factor in causing this accident. Substantial factor is the test, Justice Levy, I think you asked me right at the beginning, right? You have to be, the negligence has to be a substantial factor. There's no way this can be a substantial factor. Could it be a minute factor? Could it be a scintilla factor? Maybe, but it's definitely never going to be a substantial factor.
Are you familiar with the Smith and Wesson case decided by the First Circuit against Mexico's case?
Correct, I am not.
That issue of causation was decided against the gun manufacturers at the circuit court level, but argued at the U.S. Supreme Court.
And Your Honor, we're highly confident that the fact the Supreme Court took that case on motion to dismiss on the First Circuit is going to be evident in about a month and a half.
I will say, having listened to the oral argument, I wouldn't bet against you on the causation issue, but right now we have a First Circuit case, not binding, but it's pretty persuasive authority on causation that's even more remote than this. In the Mexico case, you had so many intervening criminal acts from from the manufacturer all the way to the cartel in Mexico. Here, it's a little shorter of a chain. I'm not saying it's too short, but
I don't know if it's a shorter or longer chain, Your Honor. I would say it's a different chain, right? So in Mexico, they sued manufacturers primarily for one distributor. But the argument is the manufacturers sell to distributors sell to retailers, the retailers allegedly sell to people with their intent, with guns, those people bring them across the border illegally, then they sell them illegally in Mexico, and then the Mexican cartels use them to commit cartel acts. So you have 6, 7, 8 steps. I think Mexico would argue is 3 or 4. Here, I mean, we're not even selling the firearm, right? We're not selling the ammunition. So we're not even, so in cases like Williams or King, which this court has dealt with, you had, in King case, you had a retailer selling ammunition that's actually used. In Williams, you had a dealer, distributor, and manufacturer selling the actual firearm that was used. Here we have a pin that was an aftermarket accessory or component part to the gun that then was removed and wasn't even a part of the crime. So I think it's a different chain, it's a different product. I don't think you can analogize Mexico to Smith and Wesson.
look, we understand there's other ways this crime could have been committed. If you didn't have a 30 capacity, a 30 bullet magazine, you could have brought 3 or 4 handguns with you. It's not as though you would have gone in there with just 10 bullets into the store perhaps, but your time, you don't want to shift your argument to the PLCA issue.
I'm happy to do it. So the PLCA was enacted in 2005 to protect firearms industry and ammunition industry from predatory lawsuits brought by municipalities, individuals that were seeking to hold the firearms industry liable, civilly liable for crimes committed as a result of misuse, criminal misuse of their products. Here, we clearly have, and they've defined what's a civil liability, qualified civil liability action as a suit against a licensed manufacturer or seller of a qualified product that was intentionally or criminally misused to harm a third party, used by a third party to harm a third party. All of those elements are here. The issues here is, well, one, is being a manufacturer. Plaintiffs, friends on the other side, claim that they're not a manufacturer. They're clearly a federal firearms licensed manufacturer. That's a specific license issued by the federal government. You can have a manufacturing license, or you can have a seller's license. Ammunition, you don't actually need a license, except in Europe, but that's some other stuff. But it's undisputed in the record that Lean has a federal firearms manufacturing license.
But I think you're on solid ground there, but what about accessory versus component? And is a magazine There's cases, I'm sure you're familiar with the Ninth Circuit case, Duncan, that came down recently. That dealt with a magazine under, it wasn't the PLCAA case, it was the right to bear arms or Second Amendment, but it does kind of inform our analysis. Is it a magazine was accessory there?
Yeah.
Is a magazine lock more of a component than a magazine?
I would say no, I would say magazine clearly has to be a component part. I disagree with the courts that have found that it doesn't. I think, and I'm not sure about nothing, but I know that some of the cases that have dealt with this issue have talked about whether a 30-round magazine or a quote-unquote high-capacity magazine is an important part. And they distinguish that from a 10 or 50-round magazine, which I don't think any court who has looked at it just, maybe except the trial court level, Nevada case that's like.
This is a Rhode Island and a Vermont trial court case, but would you agree that if Duncan is right, that a magazine is an accessory? If that's right, I know you disagree with Duncan.
If the court doesn't think a magazine is an important part, then I don't think that I can stand up here and convince you that the mean lock, which is a replacement for the magazine release button. So that the magazine, if you believe that, you start with the premise that a magazine is an important part. And I think Lowy has found that, the E-Rate Academy case found that. I know it's sort of, I don't want to call it dicta, but it's not, it wasn't the central issue. It wasn't an issue with Lowy. And that's on the
I mean, you have Prescott as a bump stop, like you said.
correct, and Prescott kind of goes, supports us on that, because you can clearly discharge a rifle without a stock on it, right? You can take off the stock and pull the trigger. Honestly, you could probably discharge many firearms without a barrel on it. It's gonna be not very accurate, but it will discharge around, it's probably gonna hurt you or people around you. But if you believe that a barrel is a component part, a trigger is a component part, a firing pin is a component part, a hammer is a component part, a stock is a component part, I don't see how you don't find a magazine a component part. Because a semi-automatic pistol or rifle or shotgun, the term semi-automatic becomes not a non-issue without a magazine. You can either load it through the breech, which is not easy to do, especially on an AR-15, or you can load it through a magazine. Those are the only two ways to do it. And if you don't have a magazine release button or the mean lock, you put the magazine in, the magazine falls out. It doesn't stay in on its own.
Their theory, as you know, is as long as AR-15 is capable of firing a single bullet, then anything else is an accessory.
Yeah, and I find the argument absurd. I mean, I know that's what the Nevada trial court held, and I can't remember the name of the case right now, but it just,
Agree with you.
yes, I think you're right, versus Casey Knox or something like that. If it's a great open shotgun, it's supposed to fire 1 or 2 shots, depending on how many barrels you have, right? That's the way it works. If it's a pump shotgun, you pump the gun. If it's a semi-automatic, the design of the gun is to fire more than 1 round without having to reload. And if you take out the magazine as a component part, whether it's fixed or detachable, then it's not semi-automatic anymore. That term becomes a nullity. I don't know what it is, it's right.
You agree with Judge Van Sly's dissent in Duncan?
Yes.
His
And then I just, with his videos.
video dissent is kind of unusual, but
Exactly, very
But
unusual.
anyway, let's assume we agree with you on component part. They then say, well, the exception under the statute applies to violation of state or federal law that deals with something like
And so the problem they have there is, and where they were successful in Williams and King, is you had Gun Control Act regulations and laws that they allege specifically, whether it's selling handgun ammunition to a person under the age of 21, which is a violation of the Gun Control Act, or Williams, selling a firearm to someone you know to be an illegal purchaser or straw purchaser. So they have concrete statutes, federal regulations that they allege were violated. Here, because we're not dealing with firearms, we're not dealing with ammunition, there is no Gun Control Act, National Firearms Act, ATF regulation, state law.
Plus the SAFE Act, they seem to say that your client aided and abetted individuals in violating the SAFE Act by giving them this permanent lock that can easily be removed and make it a fully
I agree that's their claim, and I'll go back to Mexico real quick, because Your Honor, you know that that's one of the 2 issues that the Supreme Court is dealing with. The Supreme Court is dealing with 2 issues in Mexico. It's whether an aiding and abetting claim is sufficient to allege a predicate violation, and 2, whether the proximate cause language used in the predicate exception what definition should be. I think if you listen to the argument, you've heard a couple of the justices have concerns about going to the proximate cause issue because it's sort of, like, I can't remember the term Judge Sotomayor's issue, but somewhat of a quagmire in terms of.
Nobody expressed any concern with the federal gun statute being a statute that would fit the exception for the placard. Nobody questioned that. It was whether there was enough evidence of the aiding and abetting, and if so, whether it's proximate cause. So it seems to be, is the SAFE Act any different than the federal law there that was allegedly violated?
I think it would be hard to argue that the SAFE Act is not a law designed to regulate the sale of nuclear firearms. So I would agree with that. The problem I have is the 349, 350, obviously, because those are generally applicable consumer fraud type statutes that we believe fall under Beretta and fall under Alito, that those aren't specific enough. You can't use a generalized thing. But
Are you agreeing that the SAFE Act is a sufficient predicate statute for the exception?
it depends on what part of the SAFE Act. I don't think so 898, I don't know if that's part of the SAFE Act, or in addition to sort of an addendum to it. But if you're talking about generalized regulations, whether firearms companies must act reasonably, I don't think that is sufficient to qualify as a predicate statute. I think the predicate statute has to say, you shall not sell a handgun to someone under 21. You shall not sell any handgun ammunition to someone under 21. You shall not sell a firearm to someone who you believe to be a felon. Or
You should not sell a firearm with a magazine capacity greater than 10.
I agree with that. And so Dean's sole intention, according to the advertisements, according to the complaint, was to make an otherwise illegal assault weapon in New York into a legal one. Now, whether it accomplished that or not, and the problem with that argument by the plaintiffs that it didn't, is that no one ever said anything to me, no one ever said anything to anyone before this incident, that this somehow was not sufficient.
Am I understanding it correctly that when the SAFE Act came into existence, manufacturers in New York would meet with representatives of law enforcement, ATF, Attorney General, and say, look, this is what we have, can we get approval for this? And if so, was that done with the means law?
I'm not aware of any system in place in New York where you can submit a plan or a prototype or a potential product and ask for sort of an advisory approval. I'm not aware that that exists. I know some states do have that. ATF has it for certain things, but obviously ATF have nothing to do with this. I don't think there's a mechanism.
Yes, not done. All right, you have a few minutes left. Any further points you want to make here?
Let's see. I know that I probably talked about proximate cause a little too much already, but the one case that I really think kind of encompasses our argument here is a case called Flores versus Dearborn Management. It's 2483, 101 out of the First Department in 2005. And the language is, and again, that was not a motion to dismiss, so I understand that, but it was a verdict entered against the landlord. It was unanimously reversed on the law. The directed verdict was granted to the defendant, despite the evidence of the landlord's negligent security. So going back to Judge Burns mentioned, we're starting with the fact that there was negligence. The evidence also clearly established that the murders were the result of a planned hostage taking and armed robbery, incident to the intended murder of the specific target in his apartment. Such intentional conduct was, as a matter of law, the sole proximate cause of the decedent's death. This is what we have here. We have a planned attack, meticulously planned, with specific targets, and that intentional conduct was the sole proximate cause as a matter of law. We'll stand on our briefs with respect to the arguments with respect to whether plaintiffs have adequately alleged a public nuisance claim, and whether this court has personal jurisdiction over me. If there's any questions, the rest of it.
Thank you, Counsel. Mr. Commissioner, well.
Good afternoon, and may it please the court. My name is Eric Hirschwell on behalf of the plaintiffs of the Jones and the Harris Stanfield cases. And just before I jump into my arguments, a quick roadmap, we've divided up the arguments among the plaintiff's lawyers. And unless the court would like us to change the order based on what
I'll
was
leave
heard.
you to proceed.
Okay, great, Your Honor. And just as a quick preview, I'm going to focus on the threshold issues under the Protection of Lawful Commerce Norms Act, which I'll refer to as PLACA. And then Ms. Elmore Garcia, my colleague, is going to focus on some of the substantive New York law issues under General Business Law 349 and 350, and touch on personal jurisdiction. And then Mr. Grable will finish for the plaintiffs, focusing on proximate cause, which you've heard a lot about already, and public use. So with that, let me jump in, and I just want to spend 2 or 3 minutes on the facts, because I do think that they are important to these legal arguments. And as the court, of course, knows, the case against Menar centers on this product. You see it here at counsel table, that they manufactured, marketed specifically to consumers in New York, the MA lock. And as this court has alluded to, really the key to understanding the product starts with New York's passage of the SAFE Act in 2013. And when that law was passed, and we quoted the bill jacket in our papers, what the legislators of this state said was that some weapons are so dangerous and some ammunition devices so lethal that we simply cannot afford to continue selling them in our state. What we've alleged in our lawsuits against Mean is that its MA lock was an aftermarket product, again, targeted at New York, that Mean claimed would turn illegal assault weapons into legal weapons. But as we've laid out in detail in our complaint, they lied and they misrepresented. They said the lock was a permanent change when they knew it was not. They said that the lock could not be removed with a tool when they knew that it could be. And as the court has already observed, they boasted to their customers about how quickly and easily the lock could be removed, and they provided
You
instructions.
said they lied that the lock couldn't be removed, but on the packaging, it shows exactly how to remove it and gives advice on what type of screwdriver to use.
That is correct, Your Honor, and in other marketing, they specifically say it cannot be removed with a tool, and they say that to try to demonstrate that the change was a permanent one. Their own marketing used the word permanent.
So they were speaking to 2 different audiences. Permanent was for law enforcement. Okay, we're gonna be compliant. You can remove it, that's for people who want to break the law in New York. Is that your 2 separate audiences that they were directing different messages to?
I think what we would suggest is going on here, based on the facts that we've alleged, is a marketing campaign that is essentially a wink and a nod. We're going to pretend and present our product as if it complies with and allows you to comply with New York law. But they knew that it did not. Why else would they lie specifically about certain things? They never disputed anywhere that these false assertions weren't made. So that is our theory of the case. Obviously, these are factual issues that we believe the jury should hear. But let me just continue, because what's so important here is that the shooter did exactly what he said one could do with the lock. He sought out and he found a Bushmaster AR-15 assault weapon with the MA lock attached and a fixed 10-round magazine. Then he followed Mean's instructions. The same day he got the rifle, he was able to quickly and easily remove the lock. He then replaced it with a new magazine release button, and so now he had an AR-15 illegal in New York, ready to accept detachable, large capacity 30-round magazines. And that meant that he was able to kill and wound more people more quickly in this racist rampage that
Did
he
you
carried
agree
out.
with counsel that the shooter did not need a means lock to render his AR-15 lawful under the SAFE Act? There's other, if you get rid of the other features of the assault rifle, you can have a magazine that comes out, a detachable magazine. And so this wasn't, there were other ways he could have had the same rifle without this lock.
There are other ways, but what we've alleged and what I think that the diaries show and they're set forth in detail in the complaint is that he specifically wanted an AR-15 style rifle with detachable magazines with all of the features of an assault weapon in order to carry out this massacre. And what we've alleged is that had he not been able to find this weapon in New York with the MA lock attached, which he would easily remove, that either he would not have been as emboldened as he was to carry out the shooting, or if he did carry out the shooting, perhaps with different weapons, less lethal weapons, that the outcome would have been different. And there's a particular fact with respect to one of our clients, our client's mother, and that is literally in the middle of gunning down Celestine Cheney. She is the mother of my client, Wayne Jones. She was a 65-year-old grandmother at the time. The shooter ran out of ammunition from his 30-round magazine. But because he had been able to remove the MA lock, he could quickly change magazines, reload his weapon, and continue his rampage.
He could have reloaded it even without the magazine, if the magazine lock was still in place, but it would have taken a lot longer than somebody could have do it from Mrs. Yard. Do you want to
That's
move on?
exactly right.
Do you want to move on to PLACA?
Absolutely.
Whether it's a qualified product or accessory?
Yes, and what I'd like to do is I absolutely want to address that. I'd like to first, though, address the manufacturer question, because I think there is a dispositive threshold issue here. And what counsel for Mean has said, and what the record reflects, is that Mean is a licensed manufacturer of firearms. They have a Type 7 license with the federal government, and that is undisputed. But if you look at the definition in PLACA of a qualified civil liability action, and specifically the definition of a manufacturer, there are two requirements. Being licensed is one of them. The second is being engaged in the business of manufacturing firearms. And nowhere in this record has Mean even asserted, much less introduced any evidence to show that it was engaged in the business of manufacturing firearms. So that can't be a basis for them to be found to be a manufacturer. Now, maybe their argument is quite unclear in their papers that they are a licensed manufacturer of this MA lock. But that argument doesn't work either, because there is no license required to manufacture.
Well, they seem to
that lock.
piggyback on the manufacturer of the firearm itself. Because they're covered under the statute, and they seem to. But what about the accessory issue that I think is a little closer than the one that you're talking about?
And Your Honor, just to, if I could say one more word on
Yeah.
it, because I do think it is absolutely dispositive here. You don't get to whether it's a qualified product if they're not a manufacturer. And I would submit that on this record, they have not established both parts of that manufacturer test. Whether you think of the qualified product as some other manufacturer's firearm, the Bushmaster, or you think of the qualified product as that lock, they simply cannot meet the manufacturer test. Full stop. PLACA does not protect them. So let me turn to the qualified product issue. And sort of two critical points here. And the issue before the court is whether, right, that product there, the MA lock, is a component part of the firearm. I think there are two ways to think about that. One is sort of a common sense way, and then I want to look again at the text of PLACA, which I think does give us the answer. From a common sense perspective, this is a product not sold with the weapon when it was originally sold. It's an add-on product. It's an easily removable product. In their own words, it changes the way the weapon functions. And of course, it is nowhere to be seen at the time of the horrific murders that took place. So from a common sense perspective,
Well, they say it was replaced with another product.
it was
So it just
replaced.
wasn't removed. It would be different if it were removed and not replaced, but it was removed and replaced, and that's how they get it as a component part of it.
So let me turn to the textual issue, which I think reinforces the sort of common sense notion, because you first have to decide what is the definition of component part. It's one of the few terms that actually Congress did not define in PLACA. And component part, I think actually the parties are in agreement, is an essential or integral part of a firearm. There doesn't seem to be any dispute about that. What's critical here is that PLACA says for Mean to have protection, they have to be the manufacturer of a component part of a firearm. And they define firearm, and they direct this court to the definition of a firearm in the Gun Control Act. And what that definition says is that a firearm is a weapon that will expel a projectile by the action of an explosive. And in plain English, that is a firearm is any weapon that can fire a single shot.
Doesn't say semi-automatic firearm.
That's exactly right. And here's where I think Mean has made an argument that just doesn't work. Because their argument is that that MA lock is an essential component either of the semi-automatic rifle, because you can't operate a semi-automatic rifle without it, or they say as a compliant New York rifle. That may be their argument, but what Plackness says, the question is not, is it a component part, is it essential for the weapon to be able to operate as a semi-automatic rifle, but is it a component part of the firearm? And they have conceded in the record below, and I can read it to the court, that the AR-15 rifle becomes a single shot rifle. Those were their words, it's in the record, pages 1309 and 1846 without the lock. That ends the inquiry here under PLACA, because that means it is not a component part, it is not necessary or integral for that weapon to fire a single shot. Therefore, it is not a component part of a qualifying product. Now, Your Honor referred to some of the cases on firearms, magazines, and bump stocks. And I think they are instructive. The court mentioned the Green case. The Green case is a state court trial court decision in Nevada. And that court, I would submit, got it exactly right. What the court there found was that a 100-round magazine was not a component of the firearm because the rifle could fire even if it wasn't attached. And that is what PLACA requires this court to decide.
That was the Duncan court found in the Second Amendment context?
I think it's absolutely consistent with that, yes. And Mean relies principally on a different Nevada decision from the federal district court there, the Prescott case. And if we look closely at the Prescott case, the decision is essentially half right. What the court there decided was that a bump stock replaces a regular stock. The parties are actually stipulated that a regular stock is a component part. And then the court said a bump stock or a stock is necessary for the weapon to function as a rifle. And you can see in the court's decision, it looked up the definition of rifle in the dictionary and saw that a rifle is a weapon fired from the shoulder. And so it is true that a stock or a bump stock is necessary for a rifle to be fired from the shoulder. So the court answered that question right. It's just that's not the question that PLACA asks. It doesn't ask, is it a component part of the rifle that can be fired from the shoulder? It asks and demanded this court to answer the question, is it a component part of the firearm? So I think the court in Prescott made a wrong turn. Actually looked at the briefing. I think the parties argued it the wrong way. They presented it as a good question. Yes.
What about the, any other cases you want to bring to our attention? There's some, I think, Rhode Island cases and others. There are, your briefs will come along your next point as well, that would be better.
Yes, Your Honor, I'm happy to continue. There is a third reason why we've argued that these cases that we brought do not qualify as qualified civil liability actions. And that is that PLACA also requires not just criminal use or misuse, but actually misuse of the product. In other words, using the product in a way that is not intended to be used. And as the court's prior colloquy, I think, reflects, here we've got a company that markets its product as a quickly and easily removable lock, right? As part of their marketing campaign. So we would submit that it is not misuse of this product, or at least has an issue for a fact finder to decide when the shooter decided to remove the lock, as the media boasted about it and actually provided instructions for them. The last point I want to make is about our aiding and abetting or facilitating a violation of the SAFE Act. So now we're moving past the qualified civil liability action question to the predicate exception, this court, of course, is familiar with. All four of our lawsuits allege predicate violations of New York General Business Law 349 and 350. And as I mentioned, so I want to see, we'll turn to those in a minute. Our two cases, the the Jones and Harris Stanfield cases also allege a predicate violation based on facilitating violations of the SAFE Act. And I think as your Honor correctly noted earlier, there's really no question, although he argues to the contrary, that facilitating or aiding and abetting a violation of a law that is specifically applicable to the sale of firearms or assault weapons under the SAFE Act cannot be sold, cannot be possessed, or is a predicate violation. The Williams case from this court, the Smith and Wesson versus City of Garrett case from Indiana Court of Appeals, both stand for the proposition that when predicate violation is aiding and abetting underlying statute, you look to that underlying statute to see if it is applicable to the sale or marketing of firearms. So I think you easily satisfy that standard. They also argue that there's no evidence or suggestion that the sale of the rifle was an illegal sale and that somehow they were never put on notice, as we heard here today, that the law was insufficient. And what I want to say about that is two things. One, the SAFE Act required the state of New York and the state police to issue guidance about which weapons fell within the prohibited category and which did not. And we put that guidance, which was on the New York State website for all to see. And I would submit the only reasonable inference to draw from the fact that Panini used the word permanent in its marketing is that it was well aware that the state police said that if you want to modify an illegal weapon into a legal one in New York, you need to make a permanent change. And so we would suggest that there is plenty of evidence or allegations here in the state that they were unnoticeable and required and acted contrary to that. And finally, on the issue of intent and knowledge, I focused the court's attention on facilitation under Penal Law Section 115. As the court no doubt is aware, that requires only that the facilitator had provided assistance believing it was probable that he was rendering aid to another in committing some violation of New York law. And here, we have significant allegations that mean not only knew it was probable, but in our view, and drawing all the inferences in favor of the plaintiffs at this stage, based on their marketing campaign, actually intended that people in New York would remove the
Would
law.
knowledge be enough? Because there's the distinction between knowledge and intent that was drawn in the Smith and Wesson case. Are you saying you need both, or are you okay with, can you satisfy your verdict with just knowledge, no intent?
So we would say that knowledge is enough. The standard under New York law is believing it probable. So if they had facts, and we can demonstrate that they knew sufficient information to believe it was probable that people in New York would remove the law, and again, based on their marketing, we would submit not only did they know that, but as part of their marketing plan, then yes, that would satisfy the mens rea requirement.
Thank you very much.
Thank you.
I'm more going to
Good afternoon, Your Honors, and Police Court. I'm Kristen Elmore Garcia, an attorney with John B. Elmore, PC, representing the Patterson plaintiffs. For 11 million days have passed since this tragedy, and it is still my hope that this matter will receive a trial and allow these plaintiffs to speak in their own words the lasting impact of 2014. Affirming the decision and order of Honorable Justice Oliver, but over his one step closer from that goal. The Patterson plaintiffs will give out the arguments that put forth by Attorney Garrett Hirschwell, including the fact that this is not a qualified civil liability action, nor is the Emory Walker qualified property law. However, even if Your Honors were to just make those decisions as negative, the predicate exceptions under 15 U.S.C. 7903 5A2 would still allow these claims to proceed. These allow claims where a manufacturer or seller knowingly violates a state or federal statute applicable to the sales or marketing of a product and where that violation is the proximate cause for the harms.
Your position is those laws don't have to be specifically related to firearms, they can be general, that products would include firearms, but they don't have to be geared only toward firearms.
Correct, Your Honor, and actually no court has ever decided that a statute, a predicate statute must be exclusively applicable to firearms. I'll get through some of the case law, but we ask you merely to decide in accordance with this question that's been before many other courts. It gets to the heart of the issue of what PLACA stands for, which is the protection of lawful commerce in arms. We have allegations that PLACA's conduct was false, unlawful violations of general business law 349 and 350. They introduced their MA product into New York's marketplace, intending to circumvent our state's fixed magazine requirement for certain semi-automatic weapons. They marketed this device online as a quote, true solutions to New York's assault weapons restrictions, while simultaneously marketing it as a product that could be easily removed in 4 simple steps without damaging a firearm. This is a dog whistle lock. The underlying message is clearly understood, and their deception played a direct role in the
Can I ask you about that? Because you make a lot of sense there, but was anyone ever charged with unlawful possession of one of these firearms? It means law enforcement charged the seller here with crime of selling? Because it sounds like it was an unlawful assault rifle under your theory, but it means not, right? Because it wasn't permanent.
ultimately, it had the image of being lawful.
So if somebody's walking around with an AR-15 with the lock on and all the other features of the assault rifle, that's a violation of the SAFE Act right now, somebody's got it.
The violation of the SAFE Act, the violation of PL 265 would be the fact that this lock did not prevent the weapon from accepting the detachable magazine. If we were going to design a product that was capable of preventing this weapon with the prohibited features from accepting the detachable magazine, they could have designed a lawful product. Instead, they chose to design a product that could be easily removed and did not damage the weapon. We just want you to follow the same reasoning as courts in Connecticut, Nevada, Texas, and California that have recognized that these consumer protection statutes would fall within the scope of the predicate exception. New York versus Beretta followed that same reasoning that statutes don't have to explicitly reference firearms. Beretta versus Block from the Ninth Circuit also rejected the idea that a predicate exception has to apply exclusively to sale and marketing. The facts of this case, unfortunately, are so remarkably similar to Soto versus Bushmaster at the aftermath of the St. Hook Elementary School shooting. And in that court correctly held, and I quote, that if Congress had intended to limit the scope of the predicate exception to violations of statutes that are directly or expressly or exclusively applicable to firearms, it easily could have done so.
There's no question that we follow Soto, we went on that issue. Those were consumers from Connecticut, consumer laws, not really. It was exhaustive analysis there from the Supreme Court. If we agree with that, it's not binding, but if we find it persuasive, then you win on that for sure.
So in this instance, Means conduct was clearly dishonest. They ran a very extensive online marketing campaign during the Delta scheme, making it appear as though it's a lawful permanent solution. Meanwhile, you can go to Home Depot or any local hardware store and buy a very basic screw extractor and remove it in less than 10 minutes. So our pleadings are more than extensive. Paragraph 675 through 693 of our pleadings demonstrate that unlawful marketing campaign. Further, the shooter researched this particular weapon, this particular XM13 found on the shelves of vintage firearms because it actually had that MA lock. And I'm quoting from the shooter's Discord log directly. He states that Bushmaster at Vintage Firearms will do very nicely. It has the Mean Arms fixed mag release. He selected it because Mean marketed it as so easy to remove. He was a follower of the marketing campaign and did exactly what he told him to. So their campaign basically is encouraging their customers to remove it. As far as standing, Your Honor, standing to pursue these claims on behalf of our plaintiffs is indisputable. He is arguing that families and individuals who suffer death, injury, and trauma lack standing simply because they are not the ones who purchased the eminent block themselves. If you follow their reasoning, only the shooter would be the one to be able to bring these consumer protection claims, and that would be absolute absurdity. And Justice Furlow correctly recognized that, and she affirmed that the statute allows, quote, any person to bring such a claim. He concedes that point in the record on page 389 of the record. They say themselves, a plaintiff need not have actually relied on the alleged deceptive conduct to assert a claim under section 349 and 350. So Your Honor, I believe on that point as well. And as to personal jurisdiction, Mead's product was deliberately marketed to circumvent New York law. As you heard from Counsel for Mead, there's essentially no other market for this product outside of states like New York that have these fixed magazine requirements for certain semi-automatic weapons. Their website states that they satisfy California and New York law. Prior to May 10th of 2023, their website stated that they had no issue shipping to New York. To state that this court wouldn't have jurisdiction over me would be offensive. Lastly, even if you were to rule that this eminent block is a qualified product, or that our general business law 349 and 350 claims are not adequate for exceptions, we still have the additional general business law 898A through E claims. These do expressly mention firearm. So Your Honor, we would respectfully ask that you confirm Justice Furlow's decision.
Thank you, counsel. Mr. Brady.
Thank you, and may it please the court, my name is Jim Grable, I'm a lawyer at Congress LLP, and we have the privilege of representing 12 families in what's been now known as the Salter complaint, the Salter case. And we divided up the work, and I drew proximate cause and public nuisance.
You're going to finish where counsel started.
We're going to finish where we started. Correct. Mean has made a couple of arguments about proximate cause. You heard a lot about one. I'll talk about both, and of course, answer any questions the court has. The first argument in the briefs is that the federal statute provides a proximate cause standard because that phrase appears in the predicate exception. Different than New York. There's never really much discussion about how it's different. The implication in the brief is that it's like super proximate cause, a proximate cause on steroids. But when you look at the case they cite, which is the city of, the Bank of America versus City of Miami case, that case, I know Your Honor said you listened to the oral argument in the Estados Mexicanos case. Whenever you hear this discussion about the notion of federal proximate cause, it comes back to the same discussion that Judge Ferrarello did in our case, which is the notion of foreseeability. That whether it's some federal standard that's never yet been decided or delineated, or whether it's New York's really well-established standard, the standard is the same, foreseeability. And the court was right to focus on that here this morning with the questions. And so was Judge Ferrarello, to her great credit. She talks about the fact that it has to be foreseeable. In New York, we start with the proposition that the general proposition is a jury question. And it is. It goes to a jury in New York. There can be rare circumstances when, as a matter of law, it can be said, the causal chain is set.
We sometimes really do it on summary judgment, almost never on 3211, usually a trial, but there are a lot of these cases. You read them all over the country, 12B6 motions are getting dismissed in federal court all the time. That's our equivalent of 3211. So it's not impossible, and there are some facts where it would be appropriate. They seem to rely heavily on the intervening crimes, not just the shooting itself, but removing the lock to make it a violation of the SAFE Act. Does it have to be foreseeable to Means down in Georgia, and they make this product, that all of these acts criminal acts, intervening acts are going to occur that's going to result in this tragedy at the Buffalo Top Story?
It certainly needs to be foreseeable that the product will be used in the way they intended it. Mr. Walsh conceded that today. I don't think any of New York's cases stand for the proposition that the tortfeasor has to see every step along the causal chain. That would be an absurd proximate cause standard that nobody could clear on 3211.
But you would, conceivability and foreseeability are two different things.
Understood.
And you could conceive of, anything could go wrong at any point. But is it really likely, foreseeable, probable? I don't know if probable is the right standard, but these things happen, but very infrequently. Is it enough to get you past 3211?
This court answered that question in a really, in an intelligent way in the Williams case in 2013. And Mr. Walsh and I were here for that case. When we argued in 2012, and foreseeability was an issue in that case, just as it is in this case. It's not mentioned in any of Means' briefs, and with good reason, because it's a case that's dead set against them. But at that time, this court found in a case like this one, where there's a criminal shooting that took place that harmed Danny Williams, our client at the time, the court said that Caldwell, the shooter, his intervening criminal act doesn't necessarily sever the causal connection, because it's a normal or foreseeable consequence of, as the court put it then, it's an issue of fact whether providing large quantities of guns for resale to the criminal market would result in the shooting of an innocent victim. In that case, you had a bunch of steps along the way, some of which were unknown to this court and to the trial court. Steps that you can't know often in cases. But there's an unbroken line. The line flows directly from what is foreseeable to what happens. And here, it's foreseeable that if you're in New York and you've purchased a gun that has Means MA lock on it, it's foreseeable to mean that someone's going to take it off and utilize a high-capacity magazine. Why else would you utilize that aspect of what the MA lock does, unless you intend to take it out and utilize magazines, detachable magazines, that you're not supposed to utilize, fixed magazines that are law in New York? Mean knows that, it's foreseeable to them. And we don't have to look any further than the shooter's diary in this case, which is referenced in our complaint, and in each of the complaints, where the shooter calls out Mean by name. The shooter didn't just pick this gun. I heard Mr. Walsh, my colleague, say earlier, you talked about how there's all these steps that really almost imply that they couldn't have been foreseeable. The shooter tells us here that he wanted, and that's in the complaint on the 32 that he needed a gun. So this isn't just but-for causation. This is proximate cause. He picked this gun, and it was foreseeable to mean that he and others might utilize it in exactly the way he did, because they tell people how to do it, and they give them the guidance on how to do it. And so, Means tortious conduct flows in a straight line, right? Do we know all the steps along that chain? No, we don't have to know the words. All we need to know is that it's foreseeable to them at the start of that chain, that what happens at the end of that chain is likely to happen or could happen.
The U.S. Supreme Court reverses in Smith and Wesson, Mexican case, on proximate cause. What does that tell us here? What is that? How does that affect this case?
It won't change the outcome.
Why is it?
Because under any calculus of proximate cause, the kind of foreseeability that you have here, where the chain is so unbroken, whether the Supreme Court articulates some new proximate cause standard under the federal statute, or the one that this court articulated in Williams, when you look at the briefs, when you look at the discussion in case law, it always comes back to foreseeability. Is that causal chain intact?
Is it a shorter chain in this case than in Smith and Wesson?
Yes, it's a shorter chain here, and New York and Williams, this court in Williams, articulated a standard that is consistent with the Court of Appeals decision in Derriere, the seminal case from 1988. This court reaffirmed that notion in Williams, and Williams has proven to be a guidepost for courts around the country that are dealing with proximate cause issues. You see it cited in various places, as it should be, because it articulates a well-worn standard of proximate cause that this court should affirm here. You know, I'm happy to pivot to, I know the court's heard a lot of argument, I'm happy to pivot to public nuisance with the court. So on public nuisance, we mirrored in our complaint the allegations that were utilized in the Williams case, the allegations that caused this court to conclude correctly that there's a proper cause of action asserted for public nuisance. We lay out the three elements. All the complaints do. Ours in particular in the record is page 255 and 56. But all the complaints lay out using the same language and the same sort of descriptions as this court affirmed in Williams 2, that 2013 decision. Those causes of action are crafted the same as they were in that case, and the result here should be the same. So if the court has other questions, I'm thinking that if the court would just permit me to close where Mr. Walsh closed. He talked about the Flores case and the notion of sole proximate cause. I know the court's going to hear a lot of additional arguments today in this case. In the wake of May 14th, and when these shootings happened, but especially perhaps in the wake of May 14th, we hear phrases like "we must never forget" and "never again." And those statements are important, and we must never. Those are essential to the what, right? We all have to remember what happened and make sure it doesn't happen again. What the court is doing today is addressing the why. Mr. Walsh talked about the sole proximate, the sole tortfeasor in the Flores case. You can have a whole lot of tortfeasors. And New York has recognized this for centuries. A whole lot of tortfeasors whose independent, individual little acts add up to a tragedy. And why is it a tragedy? Because it's avoidable. Why is it avoidable? Because it's foreseeable. It's foreseeable. And so I know the court will hear from folks such as my colleague Amy Keller Amy Keller later today, and there's a lot more. Unless the court has other questions, I will submit.
Thank you. We will shift now to cases 535 through 540.